We're glad you're tuned to KUTV News at 9. Tonight, we're focusing on the 2010 Constitution of Kenya. On the 27th of August 2020, it will be marking 10 years since it was promulgated. In Concern tonight, we'll be focusing on how well it has been implemented, the positive impact of the Constitution, and whether it's time to rebuild the statute document. We're having Professor Patrick Lumumba, who holds a PhD in Law of Cities from the University of Ghent from Belgium. He's also a former secretary of the Constitution of Kenya Review Commission, and also he acted as the director of the defunct Kenya Anti-Corruption Commission, which is now the Ethics and Anti-Corruption Commission. Welcome, Professor Lumumba.
Thank you very much.
First of all, give us the historical context of us having this constitution 10 years on, or when it started in 1965.
The history of constitution making must be understood in the context of its history. We regained our independence in the year 1963, and in the year 1964 we amended our constitution. Kenya ceased to be a parliamentary system based on the Westminster Model Constitution, and we changed the constitution in 1964 to eliminate the office of the Prime Minister and to introduce the office of the President. After that, there were a series of amendments, so fundamental in the manner in which they were. Remember, we had a Senate at that time. Those were abolished, and we became a unicameral parliament, culminating in the reissue of that constitution in 1969 as Act number 5 of that year. Then, when President Moi became the president in 1978, a number of things started happening, and after the coup d'etat, or prior to the coup d'etat, the constitution was amended in 1980s to introduce Section 2A to make Kenya a de jure one-party state. The agitation then started in earnest during that particular period, and ultimately the calls for no reforms, no elections culminated in the IPPG of 1997. After that, Kenya went into an election on the understanding that we would have a new constitutional dispensation. What then happened is that we had government introduce a bill in Parliament, the Constitution of Kenya Review Commission Act, Act number 3A of the year 2001. That act created a process which was called the CKRC, but simultaneously the civil society and some elements within the religious sector did have their own parallel process called the Ufungamano process. When Yash Gai was appointed as the chair of the parliamentary process, he brokered a merger of the two processes. Remember, the other process was led by the late Dr. Oki Ooko Ombaka. And we then had this process, a process in which I served as the secretary and the chief executive. We then went through the constitution-making process. In the year 2001, we gathered views, and we were ready to have a constitution. I remember that we convened the National Constitutional Conference on the 27th day of October, the year 2002. On the 28th of October, President Daniel Moi dissolved Parliament, and when that happened, Amos Siswila Wako, who was the then Attorney General, did issue a public statement on the 29th day of October 2002 that the process could not continue because we were running towards an election, which election did take place, and which saw President Mwai Kibaki come into power, having run on the promise that he would deliver a constitution within 100 days. That, of course, then was, there were a number of things. There are people who did not think that they needed a constitution. I remember so very distinctly John Njoroge Mishuki saying that all they wanted was to remove Moi, not to make a constitution. But that notwithstanding, on the 30th day of April, the year 2003, we congregated 629 delegates drawn from different sectors of the economy, or rather of the country, and President Mwai Kibaki, as delegate number 1, opened the conference. We sat for 110 days and ultimately came up with a draft, which was based on a draft issued by the Constitution of Kenya Review Commission. That draft is what is ordinarily known as the Boma's draft. But the Boma's draft was then taken by parliamentarians and taken to Kilifi, and they produced a draft which was in many critical instances different from the draft that we produce. That is the draft that sometimes you hear newspaper people calling the Kilifi or the Wako draft. It is that draft that was subjected to a referendum in the year 2005, with those who opposed it being having a symbol orange and those who supported it having a symbol banana, and it gave birth to a political party known as ODM. Yeah. We then went into an election in the year 2007 on the old constitutional order. Yeah. And you know what happened? We nearly went to civil war. And when Kofi Annan, Grasa Machel, and the late Benjamin William Kappa midwifed the rapprochement between the opposition led by Mr. Raila Odinga and President Mwai Kibaki, we then had 4 agenda items. Agenda items that led, number 1, so the creation of the office of the Prime Minister, stabilizing the country, and then we had agenda item number 4, a new constitution. Then the question was, how do we make a new constitution? Do we go back to the bombers of Kenya? It was then agreed through a committee that was appointed by President Mwai Kibaki called the Committee of Eminent Persons, which was led by the late Bethwel Kiplagat. It is Bethwel Kiplagat who then recommended, after hearing representation from many people, including myself, that you needed a leaner, meaner team to deal with this particular matter. That is how the Committee of Experts was put together, drawn from different sides of the political divide. When that happened, we had representation from South Africa, Professor Murray, Professor Johnson Mpembo, and Chaloka from Zambia, and we ended up with a draft constitution called the harmonized draft. Harmonized because it took into account the contents of the CKRC draft, it took into account the Bomas draft, and took into account other further representations that were made by the people. That particular draft constitution, having been generated by the Committee of Experts, was then taken by the politicians. And they had a constitution body that was created, an oversight body. They went to Naivasha, and once again they amended things. Introduced, for example, an American-style presidential system, while in all other drafts there had always been a president and a prime minister. They also interfered with the section dealing with people representation. They also interfered with the legislature. For the first time in the history of constitution making, Kenyan parliamentarians created a Senate, which is a lower house, has never been seen anywhere in the world, but they did. They also, contrary to what we had said in many drafts, introduced 47 units of devolution. And they created, of course, introduced other things, retained quite a number of things in the draft. That is the constitution, which was subjected to a yes-no referendum. Many people and many commentators have always argued that the 2010 constitution was in many ways a ceasefire document between those who had opposed Mwai Kibaki and Mwai Kibaki himself. But be that as it may, the constitution has many merits. Number 1, the introduction of devolution, its many problems notwithstanding, I think was a good thing. Although I think that the devolved units should be reduced. In our own initial draft, we had actually created regions, which would be 14 in number, with Nairobi being administered like you administer Washington, D.C. and Abuja as a federal capital. And then you would have below the region, you'd have the districts, and below that, you'd have other systems of governance. I wish that that could be the case. But as it is, I think devolution was a good thing. I think the judiciary was also improved, because the judiciary, to the extent that one can see, does now enjoy some kind of operational autonomy. The question of land was also addressed. That is how you created the National Land Commission. Although it hasn't addressed all the issues, but it's true that some work has been done. It is also true that in the area of representation, although we haven't achieved the gender balance as was contemplated, we do have better representation of women in bodies of representation, even at the devolved units. I think that the section dealing with human rights are fantastic. And I think that the creation and the strengthening of the Ethics and Anti-Corruption Commission is also a good thing. I think that the separation between the office of the Attorney General and that of the ODPP is a good thing. I think that quite a number of commissions were created, which is also a good thing, although I think that some commissions ought to be disbanded. I think, for example, that the Human Rights Commission should be expanded, and we should abolish the Gender Commission. We should abolish the Office of the Ombudsman and make them directorates within the Human Rights Commission, to borrow from what Ghana has done. And I think, therefore, that there are a number of things that are good in that constitution, and the country, to the extent that one needs to be fair, is already reaping some dividends. Another thing that I ought to mention, even the president's powers are checked. People participation in public processes is better now than it was during either President Moi or a certain stage during President Kibaki and President Kenyatta, where they administered almost by fiat. You will remember that it's during the Moi administration that we created these millionaires who were given land without paying anything for it, and they became multi-millionaires, land including forests and riverbeds. So that is what I can say about the Constitution.
Focusing on devolution, do you think that over time the executive has eaten into devolution functions as of now, given the tussle that we're seeing in terms of the revenue stalemate, the issue of resource allocation, and the functions that the counties should have vis-a-vis the executive? Has the executive sort of eaten into devolution functions?
Perhaps that is not what I want to say. What I want to say is that the architecture and the design of our devolution as it is now lacks clarity. There is a sense in which the center still holds too much. There is a sense in which we have not dealt with another critical question. The people of Kenya told us that they wanted to eliminate the provincial administration. You and me know that the provincial administration is alive and well in its full splendor. They now call them county commissioners. And there is a sense in which the center is still reluctant to release. But I hold the view that when we do look at the Constitution again, what we need to do is to give further and more functions to the counties. And remember, money follows functions. Once you have more functions, money will simply come. We can't just give you money because money is good, and we think that Kenya is some kind of cake or antelope to be divided. No, I think that a lot more could be done. But remember that there are also bureaucrats within the Kenya administration who do not like devolution. They love a centralized system because it gives you power. But such people belong to the Museum of History alongside the dinosaur. The truth is that we are going forward, and we are saying that the devolved units should be the scene of action. This is where we want to see the quality of people, of Kenyans, their quality of lives being improved. So a lot more can be done to improve devolution. But the thing that we don't want to hear, which is what we ought to hear, reduce the units. It is easier said than done, because the politicians have now made the people believe that you are going to lose big time. But when you see the conduct of the governors forming these economic blocks, they're actually saying these blocks that we are forming actually ought to be the devolved units, the primary devolved units. But as it is now, the reality is, if you wanted to reduce them, it is easier to increase than to reduce, which is very sad. But one day, I hope we'll have the courage to say that you must have viable units. The Sudanese have reduced their states in different circumstances, of course, but we too must confront that and see what it does. But a good thing, devolution.
All right. Looking at the arms of government, the executive, judiciary, and the legislature, looking at how they're relating at the moment, is that what you envisage in the Constitution, looking at the tussle of war between the executive and judiciary, and looking at the legislature on how they're being arm-twisted by the executive, so to speak?
Unfortunate. You know, the architecture is not the problem. The problem in Kenya is our political culture. Let us not blame the architecture. It's the political culture. You have people who, because they were born and bred in a culture of patronage, do not want to exercise their power. If you look at the black letter law, you look at the Constitution, the National Assembly is very powerful. There are many things that it can do. If they felt that the executive was conducting himself in an unconstitutional manner, they can impeach the executive. They have these instruments, but they have allowed themselves to kowtow to the diktats of the executive because of reasons that we do not know. There are those who say that they are manipulated, they are cajoled, some even talk of bribery. And I think that that is unfortunate. It is not the architecture of the Constitution. It is the personal or inclination of individual members of parliament who have chosen to be weak when the law makes them very strong. The Senate, of course, is superfluous. I hold the view that one of the things that we may consider very seriously is actually to abolish the Senate. We either abolish the Senate or make it a proper upper house. Because there is a sense in which we borrowed quite a bit from South Africa. South Africa has 9 provinces, and they have a council of provinces where the premiers meet. Perhaps we don't need a fully fledged Senate, but if we choose that we need it as the protector of the devolved units, let us make it a serious Senate, an upper house, like it is in other countries. And of course, the judiciary. I think that the judiciary is functionally very independent, but there is some kind of war there, some kind of Cold War. The chemistry between the executive and the judiciary is not good. And that is why you see the past is being used to punish the judiciary. But that notwithstanding, I think that largely, particularly the upper judiciary, has exercised its independence very well. They have made certain bold decisions, some of which I do not agree with, and I don't have to agree with them. I think that a number of them have been good, but a number of them, you can't satisfy everybody. But I think that a lot more could be done. I am particularly unimpressed by this tussle about 41 judges not being sworn. I think that what the president in good conscience ought to have done, if after they had been approved by the JSC, he got certain intelligence which the JSC did not have, is to remand the names back to the JSC and say, through intelligence, I now have this additional intelligence which you did not have. On the basis of this, look at it again, and those who are named adversely, you exclude them from the list and let me appoint the others who are without blemish. But for some reason, what appears to be very simple has become so complex that indeed, as at today, the 24th day of August, the Honorable the Chief Justice gave an interview in which he says he has never gotten an appointment to see his president. And I want to believe that he has a hotline. In fact, these are individuals who run different arms of government, should be talking very often. The Chief Justice of the Republic of Kenya ought not to ask for an appointment. He ought to pick the hotline and say, Excellency, can I pass by? And if Excellency is around, he says, my lord, pass by.
All right. You're an advocate of the High Court. There has been a problem of contempt of court by the executive. Looking at the conduct of the executive when it comes to adhering to the court orders, what can you say?
It is a very sad thing. When I see the court orders being disobeyed, the only guarantor of rule of law in any country is that we have an obligation to obey court orders. If you begin to disobey court orders, that is the beginning of anarchy. And it pains me. I've seen quite a number of court orders being ignored, particularly in the case of Miguna. I think it is sad. The individual is a Kenyan by birth. He acquired a citizenship of Canada by naturalization. To exclude him out of the country in the face of a court order is very painful, very painful. And that, I think, is the one area where I think the executive has really shown contempt for the judiciary.
All right. Away from the arms of government, we have the issue of the two-thirds gender rule. 10 years on, it has not been implemented. Even after 2012, the Supreme Court gave an advisory opinion on the matter. We have had Parliament, in particular the National Assembly, time and time again failed to adhere to this particular two-thirds gender rule. What is really ailing this particular process?
The problem is the architecture of the Constitution. Remember, we have 290 geographical constituencies, which are open to both gender. Remember, we have only 47 reserved seats, which are to be found in the Senate through the counties. Remember, we have 12 nomination slots. No matter what you do, as long as you don't address the fundamental question, and BOMA has dealt with it perfectly. BOMA has told the Independent and Electoral Boundaries Commission at that time and Parliament, don't increase constituencies. Retain constituencies at 210. introduce proportional representation based on party lists like South Africa, where parties go to court knowing that there are 90 seats on proportional representation and your list must be after the zebra method. Man, woman, man, woman, man, woman, man, woman. Immediately you have 45 women and 45 men. Immediately you solve the problem. And in the current dispensation, because you have 47 counties, immediately you have 47 plus 45. That gives you 92. Then you have nominations. Then you just simply make sure that you nominate more the disadvantaged gender, which for the time being happens to be women. You nominate 10 of them. Immediately you have over 100 and the problem is solved. But as long as you have this architecture, then you will have a problem because you can't just create a law that says nominate, nominate. Let us deal with the architecture of the Constitution as regards representation in this regard. Then the problem will be resolved.
All right. Now, 10 years on, we have the political class now talking about changing the Constitution. Of course, you've heard through the BBI. But some of the things that experts have raised is that whatever they're trying to solve in 10 years on is what was trying to be solved in the initial process of making the Constitution. Why is this back and forth? Why are you having this problem?
Your typical Kenyan politician, and I dare say African politician, is myopic. His vision is the next election, not the next generation. And that is the problem. And therefore, you can see that some of the problems that we now call problems were actually addressed in the Bomas draft. They were addressed in the harmonized draft. And when they got the Constitution in Naivasha, they removed all these things. Where did they come up with this pure presidential system? Who told them? Which Kenyan said that we wanted such a system? No Kenyan. They just thought, oh, beautiful, from America. And because some of us are likely to be presidents, let us make it presidential so that we look like America. That is what I think. My own view is that the time is now. Every country reviews how its constitution performs. In fact, I was involved in a review process as a consultant when the then Auditor General, Eddie Ouko, did examine our draft, or rather the 2010 constitution, and suggested a number of things to be looked at. First of all was the area of devolution. The wage bill is just too huge, and I've seen the Deputy Governor for Nyeri saying that we deputy governors earn money and we have no work. It tells you the wage bill is huge. The Kenyan government administration system is one of the most expensive in the world relative to a GDP. So there is a case for review. There is a case to look at certain aspects of the Constitution and amend certain aspects of it. Some of it is just implementation. Some of these problems can actually be implemented by way of enactment of legislation. Some of them, which they are now suggesting, at least in the first draft of the BBI, I've not heard the second draft, which is in fact not in the public domain, but I am informed, and I hope it is not true, number one, that they want to expand the executive. Those are jobs for the boys. I'm not convinced myself, although I would prefer, I want to see the architecture, but I don't think our problem is the architecture of the executive arm of government. If you hear Kenyan politicians say they want to create office of a president, vice president, prime minister, deputy prime minister, what they are telling you, we want to form an ethnic political alliance. And in order to have enough officers to distribute to ethnic kingpins, we need these officers. That is the only reason. If there is any benefit to the country, it is just by the way. It is not the intention of your typical Kenyan politician. So, in my view, there is a case for examining certain aspects, and I've counted a number of them. I think we need to be clearer in representation. I think we need to be clearer in the area, the nature of the executive. I think some commissions ought to be eliminated. I think we could do something about the judiciary. I think we ought to do something about devolution. I think we ought to do something about marginalized communities. I think we ought to do something about the question of land. And I think that if we use this occasion judiciously and addressed all those things, we would have improved what is essentially a good constitution. What is essentially a good constitution.
Tapping into what you've said, and do you particularly think that the independent commission that have been formed are working the way the Constitution envisaged? In particular, I'll point out the Office of the Director of Public Prosecution and the Director of Criminal Investigation. They're supposed to work, they're supposed to interrelate. But what we're seeing now is that one is on this side, the other is on the other side, which now makes it impossible for them to work.
Not at all. I see sometimes I'm one who is very slow to judge institutions on the basis of media report. The media is in the business of sensationalization and propagandization. So the truth is that I think that the Office of the ODPP is doing a good job. Their mandates are clearly set out in the Constitution. The mandate of the DCI is clearly set out in the Constitution. Remember that there is also a sense institutions also suffer from nostalgia, the things they used to do. And therefore, for example, in the case that was decided by Judge Odunga, in which he said that prosecution is the exclusive domain of the ODPP, which is the correct constitutional position. But remember that in the olden days, the police used to prosecute. So old habits die hard. And when they die hard and they are firmly directed that way, that is how you improve a constitution. That is how you strengthen institutions and keep them on the narrow and straight. So I don't think that there is a problem. I think that those are teething problems. It's not always going to be smooth. But as long as you have mechanisms for resolving these issues, then it's a good thing. And I think there is no problem there. And if they are being sorted out.
All right. You served as a director of the defunct Kenya Anti-Corruption Commission, which is now the Ethics and Anti-Corruption Commission. We have seen members of parliament now wanting the commission to be disbanded. They say it has failed. Do you think it is the position, or is this thing now being politicized?
A disbandment, every anti-corruption authority in Africa is always being threatened with disbandment. And whenever an anti-corruption authority hears that it wants to be disbanded, then you must know they are doing a good job. When an anti-corruption authority, nobody says it should be disbanded, it means they are not doing a good job. When you hear parliamentarians now saying, yes, it should be disbanded, yes, it should be very happy. And Kenyans should be very happy because it means they are stepping on toes. Remember, they disbanded the hawk, the scorpions in South Africa. Everywhere in Africa. But where I sit, I think the EACC is doing a good job. You know, people don't know how investigation of a white-collar crime, how difficult it is. The most successful prosecution in Hong Kong of a white-collar crime took 17 years to investigate. 17 years to investigate. And people judge an anti-corruption authority on the basis of prosecution. Remember, the EACC has 3 mandates. Education, which they are doing very well. They have prevention and recovery, which they are doing very well. In the last 1 year, they have recovered money in the billions. That doesn't go into the public domain. People want blood, they want drama, and therefore you judge people on the on prosecution and conviction. But remember, the work of the EACC is investigation. The prosecution is undertaken by the ODPP, and the examination of the evidence is by the judiciary. So it is a relay race. I think the EACC is doing a good job because I keep abreast with what they are doing. But most of the people who read occasional newspaper headlines simply judge them on a single thing. And it is not easy. It is not easy. It's not a job for the faint-hearted. Oh, no, it is not.
Now, finally, as we conclude, let's talk about the changes that BBI wants to bring into place. Some have said that it is not people-centered. It is all about politicians. Again, we go to talk about the political way of doing things. From where you sit, even though we want to change the constitution because it should be changed time and time again, do you think it is really people-centered, even looking at the BBI report 1?
You see, the BBI made the claim that they traveled around Kenya. Whether that is true, I didn't see them, but I know that they went to a number of places and they consulted the people of Kenya. Look at the consultation that our organization did, the Constitution of Kenya Review Commission. We received nearly 1 million memoranda and visited every corner of the country. So the consultation that they have indicated that they have undertaken is very targeted and in my view has not gone to to the depths. Remember, when was this BBI created? It was just in the year 2018, sometimes in 2018, and they have had a very short period. So they have done some kind of consultation. But I don't think that is thorough enough, because this is a case, in my view, where a decision has been made, and you are now trying to find reasons to justify the decision. That is how I see the BBI. So it is not, in my view, a people-driven, people-centered process in the manner that the CKRC was. It is not. It is politicians engaging in what I call mind reading of what they think the people need. But that notwithstanding, the beauty is that whatever it is that they bring, if it requires the people's decision, it will come to a referendum, and the people will meet them there. There is an assumption on the part of those who are with the who are propagating the BBI that the people will simply rubber stamp. Well, the people are beginning to shock people in Africa. And if you bring something that is not in their best interest, Kenyans will not vote in favor.
Now, looking at the Boma's draft and the Wako draft, should it have been adopted as is, we will not be having some of these challenges.
If you had adopted the Boma's draft, you talk to any of these individuals today, they'll always tell you, had we had the Boma's draft, it was carefully thought out. It had philosophical underpinnings. It was people involved. It wasn't perfect. There is no perfect constitution in the world. That is why we have provision for amendment. But it took into account the ethnicities. In fact, I remember the late Professor Ali Mazurui, who appeared before the commission during one of our meetings, and he said, if Kenyan politics is ethnically inclined, let us make a constitution that is ethnic proof. And in that Boma's draft, we try to balance all those. We are not blind to the fact that we are a nation that is comprising several little nations. And you can see the balancing act. And you can explain. I could always explain from chapter 1 to the end, from the preamble to the end, why you have this, why you have this. You can see it. Why in our draft, the chapter on national values was 9, not chapter 6. Why you started with the people, why you had the legislature first, why you had the executive and then the judiciary. There was always a logic to it. So that each chapter was informed by some logic. That logic was lost in the Naivasha draft. In proper Kiswahili, we would say, ilichakachuliwa. Walichakachua Katiba. And the net effect is that you now have what is still fundamentally good. Let me not take away the thing. Still fundamentally good. But we abandoned a better thing for that which is just good. That is why we are saying 10 years down the line, let us borrow again from Bomas of Kenya.
All right. So, Professor Lumumba, as we conclude, what can be your closing remarks 10 years later? My
view is we have come a long way. We have a constitution which generally can underpin a democratic society which is heterogeneous. Let us not allow politicians to use an occasion of re-examining our constitution to address their short-term political interests. Let us be vigilant and ensure that that occasion is used to improve the quality of our constitution for the benefit of Kenyans of this generation and generations yet to be born.
Thank you so much, Professor Lumumba, for making time and giving us quite informative insight concerning the 2010 Constitution. We are really glad.
Thank you. God bless you.
All right, that has been Professor Patrick Lumumba giving us an insight concerning the 2010 Constitution of Kenya, how far it has come, where we have lost it, and whether it is time to rebuild that particular constitution, or what you may call it, to amend the constitution.